Hello, am I audible?
Sir, you are audible, sir. We'll start in
Oh,
5 minutes, sir.
okay. Thank you, sir.
Okay, sir. Thank you, sir. Sir, shall we start, sir?
Yes, sir. Sure.
So, good morning, all of you. This is Dr. K. Kiran Kumar, Vice Principal and Head of the Department of Computer Science and Engineering. On behalf of Chalapati Institute of Engineering and Technology, Department of Computer Science and Engineering, I welcome all the participants to this webinar on IPR. So, coming to the college, CIET was established in the year 2007 under the leadership of Sri Y.V. Anjal Garu, former MLA in AP Legislative Assembly. The college was located in the capital region of AP Amravati in the Guntur city. Ours is an autonomous college under Acharya Nagarjuna University, accredited by MBA, NAC with A grade and UGC 2F. We offer both UG and PG courses in the college. Coming to the department of CSE, this is a very active department in the college. We have conducted more than 60 events in the pandemic period, which includes FDPs, workshops, webinars, STTPs, seminars, etc. Till now, more than 35,000 participants got benefited from the events which we have conducted from May 2020. So there are a total of 400 participants registered for this webinar today. Once again, I thank all the participants for registering for this webinar. And let me introduce today's resource person. Mr. Baudan Bhattacharya is an MTech in CSE from West Bengal University of Technology and working towards his PhD degree from University of Calcutta. He has worked in the capacity of systems manager for 4 years in eInfo. He also worked as an assistant professor in SDET BGI and is currently working as an assistant professor and program coordinator in Brainware University. He has published many journals and conference papers and one Australian patent to his credit. He also took part in more than 500 seminars, 100 workshops, 150 FTVs, 15 STTPs, 5 symposiums, and delivered invited lectures in various colleges, including Ramakrishna Mission, Vivekananda Centenary College, Kolkata, Doors Academy of Technology and Management, CMR Institute of Technology. He was also one of the evaluators of Smart India Hackathon 2020, 21, and 22 organized by AICTE. So thank you so much, sir, for coming as a resource person for this webinar. Over to you, sir.
Thank you, Kiran sir, for this brief introduction, and thanks for inviting me for this webinar on IPR. So, without further delay, I am directly going to the topic of the day, that is IPR, or intellectual property right. All of us know that in today's world, it is very, very important to have the intellectual property or intellectual property rights, simply because we in many cases don't know what are the properties or whether
this meeting is being recorded,
capable of being organizing it in the form of various structures or not. In this regard, in today's presentation, although we are having various forms of IPR, but as the time is a constraint, so we will only be considering two concepts. One is patent and the other one is GI, or geographical indicators. Now, let's start with IP and IPR. The IP can be defined as a property which is basically created by a person or a group of people to utilize their intellect for the use of human, and definitely that must be in public domain so that everyone can use it. For example, if you can see in the screen, that is a new design, a literary or artistic work, or a trademark, a symbol, or logo, all of this comes under the purview of intellectual property. Now, if we explore the term intellectual property right, it is basically a right, or rather a statutory right granted by the government And we must know that this right is granted by every individual country. Just like India, we can also have different IPRs registered under different countries as well. Now, thing is that why it is important to register this right? Simply because we want to exclude the others so that they can't exploit whatever we have designed or formulated, or we have made a new thing for the benefit of the society. Next, here we are having a scenario, that is why we are going for this class. That is, as the question says, can I patent my copyrighted trademark? Now, thing is that here we are having three different terms. One is patent, one is copyright, and the other one is trademark. Incidentally, all of these three comes under the purview of IPR, or intellectual property rights. So, as I have already told, due to time constraint, we will only consider the term patent and GI. So, let's start with IPRs in general. Now, the first question that comes to our mind, that is why an IP should be protected. There are various reasons. The first thing is that it is an asset and the owner must understand that no one should exploit it for any kind of commercial gains. Not only that, the owner can stop others from manufacturing or selling or services if due permissions were not taken from the owners. Along with that, an IP owner can sell or license the IP for commercial gains as well. Moving on to the next, that is, it can also be used to establish a goodwill and a brand value. Just like, suppose, if we consider any brand, we always visualize the logo, be it Coca-Cola, be it any other soft drinks or health drinks or whatever it is. Along with that, the inventor, creator or author of that particular IP, that the competence of that IP is very, very important. That means whether that particular right can be used in which segments and for what kind of benefits. And these IPR certificates establishes a legal and valid ownership for the people or the group of people who have invented this intellectual property. Now, if we go for the various forms of IPRs, we can have the following acts in India. That is the Patent Act 1970, the Designs Act 2000, Trademark Act 1999, GI Act 1999, Copyright Act 1957, IC Layout and Design Act 2000, and Plant Varieties and Farmers' Right Act 2001, along with the trade secrets. Now, we will go for a formal structure of forms of intellectual property. As you can see, the intellectual property can be divided into two segments. One is industrial property and the other one is copyrights and related rights. In case of industrial properties, we have various forms, just like industrial designs, patents, trademarks, trade secrets, GIs, layout designs of different electronic and electrical devices, just like semiconductor ICs and so on and so forth, and plant varieties and farmers' rights. Now, for all this, we need to have different acts. As we have already seen, different acts, just like the Patent Act was established in India in 1970. Similarly, all these acts, that is trademarks, designs, GIs, copyrights. Now, here are two segments. That means whether the IPs can be registered or not. If we want to register our intellectual property, we can have three forms right now. One is patent, another one is trademark, and the other one is design rights. Now, what are the unregistered? Copyright, unregistered design rights, law trademarks, database rights, protection for know-how under laws dealing with confidential information and trade secrets, which is very, very important for individual companies, plant varieties, GIs, designs of IC, and passing of trade legislation. These are the unregistered segments of IP rights. Moving on to next, we are directly going into the term patent. Now, what is patent? As you can see, it is basically an exclusive monopoly right. Exclusive monopoly means basically the person or the group of people who have invented that patent without their permission. No one is eligible to use that in any form. Not only that, this particular applicant or patentee is granted the patent for a limited period of practice. That means once a patent is granted, it is absolutely not like that. It is for lifetime. Every country have their own norms regarding this years. That means how much year the patentee or the applicant can use the patent right. Along with that, this patent right confers the rights to the patentee to exploit the patent for commercial gains and also to stop others from manufacturing and selling the patented products. That means the patentee can use this particular invention for the commercial gain, or even they can give license to use it, or if they wish, they can also sell it for the limited time frame they has been allowed regarding that particular patent. Moving on to the next, what basically an invention means. An invention is basically a new discovery related to a product or a process, or it can be a new module in an existing structure as well. Now, as per the Indian Patent Act, invention consider three different forms. One is a new product or process involving an inventive state and capable of industrial application. That means whether the invention can be used for industrial application or not. So, what we can say that we can use, or rather, the patentee can use the product or the process. Product means it can be a device, it can be a machine, or it can be a composition. In case of process, it can be for preparation of a tangible product. And it must be patentable. Now, what are the conditions or the parameters for these to achieve? Number one is the product or process, whatever it is, it must be novel. Along with that, it must involve the inventive steps and it must be of industrial use. That means, suppose I have invented something which is basically of no use in industry, the patent will not be granted for that particular process or product. Now, how a patent can be granted? What is the process involved? The first step is we need to find a patent application along with the required documents. Then, if it is approved, it needs around 18 months or 1.5 years for publication. Next, there will be an examination regarding that particular patent to check the validity or the commercial usage or whatever the patentee is applying is really beneficial to the society or not. Then a pre-grant opposition. Anyone can oppose that particular patent application if he or she wishes. After the detailed examination and the final hearing, the patent is either granted or rejected. Not only that, in India, a post-grant opposition by an interested person can also be done. Now, what are the documents that are required to file a patent? The first thing is that application form, then the specification form, drawings, if we are using any design aspects, undertaking form, declaration form, priority form, and the power of authority, whether the applicants have the authority to apply for these patents or not. These are the basic documents we need to submit while applying for a patent. Now, here we can have two types of specification. One is provisional and the other one is complete. For provisional specification, we don't need to design or send the exclusive things of that particular patent application. But in case of complete specification, we need to send all the details. For the description section, in case of complete specification application, it should describe the base mode in detail through which the invention can be practiced by the industry. Moreover, it must enable others some technical skills that are either required or the method through which the skills can be acquired, and the method to use it in terms of experimentation. Now, coming to the legal segment of the patent, we primarily need 3 points. One is key, the legal rights of the patentee and the legal boundaries of the granted exclusive rights. That means if a patent is granted in India, it means it can be used commercially in India, but not anywhere else until and unless the application has been accepted by other countries as well. And if the patentee has been granted this particular right, the person or the group of people can stop the usage of making, selling, importing, or offering for sale without the knowledge and the invention of the inventor of the patent. The thing is that who can apply for a patent? A true and first inventor who holds the rightful ownership in the invention, a person who is assignee or a legal representative of the first and true inventor, and a legal heir of the first and true inventor. That means the first inventor has the sole right to use it as per his or her discretion. That means whether he or she will assign someone else a legal representative or a legal heir of the first owner, or rather the first inventor of that particular patent. Now, where we can file these patents? As you can see in the screen, the patent offices has also have their territorial jurisdiction. Just like the Patent Office Delhi considers the applications from Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, National Capital Territory of Delhi, and Union Territory of Chandigarh. Similarly, the Patent Office of Mumbai considers the applications from Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, Union Territories of Daman and Diu, and Dadra and Nagar Haveli. The Patent Office of Chennai considered the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and the Union Territories of Pondicherry and Lakshadweep. Similarly, the Patent Office of Kolkata considers the rest of India, including the states of Bihar, Odisha, West Bengal, Sikkim, Assam, Meghalaya, Manipur, Tripura, Nagaland, Arunachal Pradesh, Union Territory of Andaman and Nicobar Islands. So, as you can see, we are basically having 4 patent offices located in 4 prime locations of Delhi, Mumbai, Chennai, and Kolkata. Now, as we already know, that is, the patent cannot be for lifetime. As per the Indian law, the Patent Act for a particular patent is applicable for 20 years. Now, what are the fees for filing a patent? If it is filed by an individual, the fees is 1600. If it is other than individual, for example, MSME, it is 4,000. And if it is filed by a private or public limited company, it is 8,000. Now, how the opposition of patent can be established? The first one is an applicant. That is, if the applicant has wrongly obtained the invention, that means somehow he or she has managed someone else's invention. Publication in any form, be it a journal or a conference or any kinds of proceedings or article, before the publication or before the grant of the patent, prior claiming. That means before the applicant is applying for a particular patent, there is already a claimant against that particular design or patent. An invention which is publicly known, that means which is already in use. Next, obvious. That means some things which are natural, which cannot be patented. And no invention as per the Patent Act. That means if the jury found that there is no novelty or no invention in that particular application, it will be rejected summarily. Next, the invention has not been described clearly and sufficiently. Undertaking whether that particular patent application has been filed in other countries as well or not. Convention application not filed within the 12 months of the application. No disclosure about the source or geographical origin. That means the references are not clearly mentioned from where the source has been taken or the geographical location for collection of data or design on something else. Anticipation. That means something which is traditionally known over the years cannot be applied for a patent. Now, whether a patent can be revoked or not, the answer is yes. It can be revoked at any time on the similar grounds as applicable in the case of opposition. That means once a patent has been published, it doesn't mean it will not be revoked if any of these points which has already been discussed, is being raised, and it is found that it is true. In that case, the patent will be revoked. The revocation application has to be filed at the office of the IPAB, or Intellectual Property Appellate Board, which is a Government of India organization under the provisions of the amended Patent Act. Now, we are having another important term, that is PCT, or Patent Cooperation Treaty. What it means? It is an international treaty which provides the facility to an applicant of the member country to file a single patent application and designate the countries in which the applicant wants to protect the invention. That means once a patentee has been granted a particular patent for a country, it can apply in terms of the extension of territorial jurisdiction for the countries who are within the same umbrella of the applicant's country. That means the member countries basically forms a peer group, and if the PCT has been applied, the same patent will be applicable in those countries as well. That means any kind of commercial usage or selling of a particular patented thing or design can be stopped by the patentee or the inventor. Now, where we can apply for a PCT? For this, we need to apply in the receiving office of that particular country. In our case, it is India, or at the office of the International Bureau, which is located in Geneva. In that particular case, the applicant can claim the date of filing as the priority date in other countries during national pheasantry. That means, suppose if someone has applied the patent on the 1st January 2021, and if it is granted by the WIPO office, the Patent Act will also be applicable in those countries as well. Now, there is very important thing, that is whether everything is patentable or not. The answer is no. Everything is not patentable. So what are they? Or what are the things that are not patentable? An invention contrary to well-established natural laws. That means the natural laws which cannot be violated. An invention which is contrary to laws of public health and morality. Just like, suppose a patentee has invented a virus. Mere discovery of scientific principles or formulation of an abstract theories which cannot be applied to industry in any way. Mere discovery of any new property or new use, substances obtained by mere and mixture resulting only in aggregation, mere arrangement and rearrangement of the known devices, method of agriculture or horticulture, methods of treatments, plants and animals in whole or any part thereof, a mathematical or business method, a literary, dramatic, musical or artistic work, etc. A mere scheme or rule or method of performing mental act, a presentation of information, topography or ICs, an invention related to the traditional knowledge, an invention related to the atomic energy. Now, coming to the GI, or geographical indication, it is basically an indication of goods originating, produced, processed or prepared in a specific geographical area or territory of a country, where a given quality, reputation or other characteristics of such goods are essentially attributed. Just like we all know Darjeeling tea. That means it is grown in a particular region and it indicates a geographical location of Darjeeling. Here are some examples of GI, that is Darjeeling tea, Kashmiri shawl, and so on and so forth. I'm not going into details to all this, Firozabad glasses. Now, what is the importance of GI? It provides a particular indication, mark or a logo to be used by the people of that area. It helps a purchaser or user of goods to identify the goods or manufacturer produce in a particular geographical location or not. That means, suppose I am producing a Kashmiri shawl at my home, will not have the GI tag, or I am producing Darjeeling tea in my farmhouse, will not have the GI tags. Not only that, it helps to establish the goodwill of that particular company and the geographical location as well. The owner of the GI can stop the usage or the adoption of the same GI or the deceptively similar GI to the registered GI by any person who is not authorized by the user. Now, what can be registered as a GI? Any name, geographical or figurative representation of any combination, and what cannot be registered as GI. The use of which would be contrary to any law for the time being in force, which comprises or contains scandalous or obscene matter, which comprises or contains any matter likely to hurt the religious sentiments of any class or section, which would otherwise be dissenting to protection in a court. Generic names or indication of goods and are therefore not or cease to be protected in their country. Although literally true as to the territory, region, or locality in which the goods originate, but falsely represents that the goods originates another territory. That means if something is being produced somewhere else, but it is originally from somewhere else. Now, who can apply for GI? An association of producers or an organization or authority established by or under any law, representing interests of the producers of the concerned good. That means, in case of patent, an individual can apply or file an application for patent. But in case of GI, it is not like that. Now, what are the particulars that are required to file a GI application? Representation of any name, geographical or figurative representation, or any combination thereof, conveying or suggesting the geographical origin of that particular good. Statement, which will be used to designate the goods, whether it is originating from the concerned territory or region, the geographical map of that particular area. Statements containing the particulars of the products, other particulars as prescribed in the application form, a power of authority if the application is being filed to a patent attorney. Now, what is the government fee? The GI fee is rupees 5,000. Now, who can use a GI? Only the persons who have the authority as the registered owner of the GI and particulars of whom has been incorporated in the Part B of the register at the GI office. That means the only GI office registered persons or organization can use the GI tag. Now, what is the lifetime? The GI is basically registered for a period of 10 years initially and can be renewed thereafter. Thus, a GI can be kept in force so long as it is renewed in a timely manner every after 10 years interval. That means there is a huge difference between patent and GI. A patent cannot have the option to be renewed, but a GI can be renewed in every 10 years. Now, whether anyone can oppose the GI or not, the answer is yes. It can be opposed by any person within 3 months from the date of advertisement of an application for registration in a prescribed manner with a prescribed fee. The person has to file a notice of opposition in writing in a prescribed manner, which is available from the GI office. Now, here is an important question, whether we can re-register a registered GI. The answer is yes. A GI can be re-registered for different goods, included in different classes by the registered owners of the GI. Next question is, Is it possible to restore a GI if removed from the register due to non-payment of renewal fee? The answer is also yes. A GI can be restored by filing a request in the prescribed manner available in the GI office. Now, what is the effect of registration of a GI? Now, thing is that the registration of GI basically grants a legal right to stop unauthorized usage of the registered GI even by the people of that geographical area. That means only the registered owner of a particular geographical area can use their product. Otherwise, if someone else wants to use that, they need to have prior permission in writing from the appropriate authority to use the GI tag. With this, I'm concluding my today's session. If you have any queries or any question, you can ask me.
The recording has stopped.
Participants, if you have any questions, you can raise your hand or you can type in the chat box so that I can unmute you.
I hope there is no question from the participant. So thank you very much, sir, for inviting me once again for this session. Although time is a constraint here, so I've just considered this GI and the patent act.
Thank you so much, sir, for your wonderful session. No more doubts, sir.
Okay. Can I leave, sir? Can
Yes,
I
sir.
leave
Yes, sir.
now, sir?
Yes, sir.
Okay. Thank you, sir.
Thank you so much, sir. All participants, feedback form is posted in the chat box of the YouTube as well as in the Zoom. Please, if you are not finding it, please refresh it once. You will find it. Please fill it, and those who have filled the form can leave now. Thank you. All of you, please fill the feedback form and then only leave. Without feedback form, certificate will not be issued. All the participants who have given the feedback will receive the certificate tomorrow. If you are not finding the feedback form, please refresh once your browser. Automatically, you will find the feedback over there. Thank you. Those who have filled the feedback form can leave now. Thank you. If you are not able to find the feedback, please refresh the browser once. You will find the feedback, and those who have filled the feedback form can leave now. tomorrow you will receive the certificates. The recorded session will be posted in the groups, YouTube as well as in the Telegram. Those who have filled the feedback form can leave now. Thank you.